Part 9. Other constitutional dimensions. 64 Cooperative societies. 65 Official language. 66 Public services. 67 Rights and liabilities of the government. 68 Special provisions relating to certain classes. 64 Cooperative societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following three changes in the Constitution. 1. It made the right to form cooperative societies a fundamental right, Article 191. 2. It included a new directive principle of state policy on promotion of cooperative societies, Article 43b2. 3. It added a new Part 9b in the Constitution which is entitled the Cooperative Societies, Articles 243zh to 243zt. Constitutional provisions. Part 9b of the Constitution contains the following provisions with respect to the cooperative societies. Incorporation of cooperative societies. The state legislature may make provisions for the incorporation, regulation, and winding up of cooperative societies based on the principles of voluntary formation, democratic member control, member economic participation and autonomous functioning. Number and term of members of board and its office bearers. The board shall consist of such number of directors as may be provided by the state legislature. Point 3. But the maximum number of directors of a cooperative society shall not exceed 21. The state legislature shall provide for the reservation of 1 seat for the scheduled castes or the scheduled tribes and 2 seats for women on the board of every cooperative society having members from such a category of persons. The term of office of elected members of the board and its office bearers shall be 5 years from the date of election. Point 4. The state legislature shall make provisions for co-option of persons having experience in the field of banking, management, finance, or specialization in any other related field, as members of the board. But, the number of such co-opted members shall not exceed 2, in addition to 21 directors. Further, the co-opted members shall not have the right to vote in any election of the cooperative society or be eligible to be elected as office bearers of the board. The functional directors of a cooperative society shall also be the members of the board and such members shall be excluded for the purpose of counting the total number of directors, that is, 21. Election of members of board. The election of a board shall be conducted before the expiry of the term of the board so as to ensure that the newly elected members assume office immediately on the expiry of the term of the office of members of the outgoing board. The superintendence, direction, and control of the preparation of electoral rolls and the conduct of elections to a cooperative society shall vest in such body, as may be provided by the state legislature. Supersession and suspension of board and interim management. No board shall be superseded or kept under suspension for a period exceeding 6 months. Point 5. The board may be superseded or kept under suspension in case I. Of its persistent default. 2. Of negligence in the performance of its duties. 3. Of committing any act prejudicial to the interests of the cooperative society or its members. 4. Of there being a stalemate in the constitution or functions of the board. v. Of the election body having failed to conduct elections in accordance with the provisions of the State Act. However, the board of any such cooperative society shall not be superseded or kept under suspension where there is no government shareholding or loan or financial assistance or any guarantee by the government. In case of supersession of a board, the administrator appointed to manage the affairs of such a cooperative society shall arrange for conduct of elections within the period of 6 months and hand over the management to the elected board. Audit of accounts of cooperative societies. The state legislature may make provisions for the maintenance of accounts by the cooperative societies and the auditing of such accounts at least once in each financial year. It shall lay down the minimum qualifications and experience of auditors and auditing firms that shall be eligible for auditing the accounts of the cooperative societies. Every cooperative society shall be audited by an auditor or auditing firm, appointed by the general body of the cooperative society. But, such an auditor or auditing firm shall be appointed from a panel approved by the state government or a body authorized by the state government on this behalf. The accounts of every cooperative society shall be audited within 6 months of the close of the financial year. The audit report of the accounts of an apex cooperative society shall be laid before the state legislature. Convening of general body meetings. The state legislature may provide that the annual general body meeting of every cooperative society shall be convened within a period of 6 months of the close of the financial year. Right of a member to get information. The state legislature may provide for access to every member of a cooperative society to the books, information, and accounts of the cooperative society. It may also make provisions to ensure the participation of members in the management of the cooperative society. Further, it may provide for cooperative education and training for its members. Returns. Every cooperative society shall file returns, within 6 months of the close of every financial year, to the authority designated by the state government. These returns shall include the following matters. A. Annual report of its activities. B. Its audited statement of accounts. C. Plan for surplus disposal as approved by the general body of the cooperative society. D. List of amendments to the bylaws of the cooperative society. E. Declaration regarding date of holding of its general body meeting and conduct of elections when due. F. Any other information required by the registrar in pursuance of any of the provisions of the State Act. 6. Offenses and penalties. The state legislature may make provisions for the offenses relating to the cooperative societies and penalties for such offenses. Such a law shall include the commission or omission of the following acts as offenses. A. A cooperative society willfully makes a false return or furnishes false information. B. Any person willfully disobeys any summon, requisition or order issued under the State Act. C. Any employer who, without sufficient cause, fails to pay to a cooperative society the amount deducted from its employee within a period of 14 days. D. Any officer who willfully fails to hand over custody of books, accounts, documents, records, cash, security, and other property belonging to a cooperative society to an authorized person. E. Any person who adopts corrupt practices before, during or after the election of members of the board or office bearers. Application to multi-state cooperative societies. The provisions of this part shall apply to the multi-state cooperative societies subject to the modification that any reference to the state legislature, state act or state government shall be construed as a reference to Parliament, central act or central government respectively. Application to union territories. The provisions of this part shall apply to the union territories. But, the President may direct that the provisions of this part shall not apply to any union territory or part thereof as he may specify in the notification. Continuance of existing laws. Any provision of any law relating to cooperative societies in force in a state immediately before the commencement of the Constitution, 97th Amendment, Act, 2011, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed or until the expiration of 1 year from such commencement, whichever is less. 7. Reasons for the 97th Amendment. The reasons for adding the above provisions in the Constitution by the 97th Constitutional Amendment Act of 2011 are as follows. 1. The cooperative sector, over the years, has made significant contribution to various sectors of national economy and has achieved voluminous growth. However, it has shown weaknesses in safeguarding the interests of the members and fulfillment of objects for which these institutions were organized. There have been instances where elections have been postponed indefinitely and nominated office bearers or administrators have remained in charge of these institutions for a long time. This reduces the accountability in the management of cooperative societies to their members. Inadequate professionalism in management in many of the cooperative institutions has led to poor services and low productivity. Cooperatives need to run on well-established democratic principles and elections held on time and in a free and fair manner. Therefore, there was a need to initiate fundamental reforms to revitalize these institutions in order to ensure their contribution in the economic development of the country and to serve the interests of members and public at large and also to ensure their autonomy, democratic functioning, and professional management. 2. The cooperative societies is a subject enumerated in entry 32 of the state list of the 7th schedule of the Constitution, and the state legislatures have accordingly enacted legislations on cooperative societies. Within the framework of state acts, growth of cooperatives on large scale was envisaged as part of the efforts for securing social and economic justice and equitable distribution of the fruits of development. It has, however, been experienced that in spite of considerable expansion of cooperatives, their performance in qualitative terms has not been up to the desired level. Considering the need for reforms in the Cooperative Societies Acts of the states, consultations with the state governments have been held at several occasions and in the conferences of state cooperative ministers. A strong need has been felt for amending the Constitution so as to keep the cooperatives free from unnecessary outside interferences and also to ensure their autonomous organizational setup and their democratic functioning. 3. The central government was committed to ensure that the cooperative societies in the country function in a democratic, professional, autonomous, and economically sound manner. With a view to bring the necessary reforms, it was proposed to incorporate a new part in the Constitution so as to provide for certain provisions covering the vital aspects of working of cooperative societies like democratic, autonomous, and professional functioning. It was expected that these provisions will not only ensure the autonomous and democratic functioning of cooperatives, but also ensure the accountability of management to the members and other stakeholders, and shall provide for deterrence for violation of the provisions of the law. Table 64.1 Articles related to cooperative societies at a glance. Article No. Subject Matter 243ZH. Definitions 243ZI. Incorporation of cooperative societies 243ZJ. Number and term of members of board and its office bearers 243ZK. Election of members of board 243ZL. Supersession and suspension of board and interim management 243ZM. Audit of accounts of cooperative societies 243ZN. Convening of general body meetings 243ZO. Right of a member to get information 243ZP. Returns 243ZQ. Offenses and penalties 243ZR. Application to multi-state cooperative societies 243ZS. Application to union territories 243ZT. Continuance of existing laws. Notes and references. 1. In Part 3 of the Constitution, in Article 19, in Clause 1, in Subclause C, the words cooperative societies were inserted. 2. In Part 4 of the Constitution, a new Article 43b was inserted, which says, "The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies." 3. The board means the board of directors or the governing body of a cooperative society, by whatever name called, to which the direction and control of the management of the affairs of a society is entrusted to. 4. An office bearer means a president, vice president, chairperson, vice-chairperson, secretary or treasurer of a cooperative society, and includes any other person to be elected by the board of any cooperative society. 5. In case of cooperative banks, other than multi-state cooperative banks, this period cannot exceed 1 year. 6. The registrar means the central registrar appointed by the central government in relation to the multi-state cooperative societies, and the registrar for cooperative societies appointed by the state government under the law made by the legislature of a state in relation to cooperative societies. 7. February 15, 2012, is the date of commencement of the Constitution, 97th Amendment, Act, 2011. The Center has asked state governments to amend their respective State Cooperative Society Act in tune with the Constitution, 97th Amendment, Act, 2011 before February 14, 2013. 65. Official language. Part 17 of the Constitution deals with the official language in Articles 343 to 351. Its provisions are divided into 4 heads: language of the Union, regional languages, language of the judiciary and texts of laws and special directives. Language of the Union. The Constitution contains the following provisions in respect of the official language of the Union. 1. Hindi written in Devanagari script is to be the official language of the Union. But, the form of numerals to be used for the official purposes of the Union has to be the international form of Indian numerals and not the Devanagari form of numerals. 2. However, for a period of 15 years from the commencement of the Constitution, i.e., from 1950 to 1965, the English language would continue to be used for all the official purposes of the Union for which it was being used before 1950. 3. Even after 15 years, the Parliament may provide for the continued use of English language for the specified purposes. 4. At the end of 5 years, and again at the end of 10 years, from the commencement of the Constitution, the President should appoint a commission to make recommendations with regard to the progressive use of the Hindi language, restrictions on the use of the English language and other related issues. 1. 5. A committee of Parliament is to be constituted to examine the recommendations of the Commission and to report its views on them to the President. 2. Accordingly, in 1955, the President appointed an official language commission under the chairmanship of B.G. Kerr. The commission submitted its report to the President in 1956. The report was examined by a committee of Parliament constituted in 1957 under the chairmanship of Gobind Ballabh Pant. However, another official language commission, as envisaged by the Constitution, was not appointed in 1960. Subsequently, the Parliament enacted the Official Languages Act in 1963. The Act provides for the continued use of English, even after 1965, in addition to Hindi, for all official purposes of the Union and also for the transaction of business in Parliament. Notably, this Act enables the use of English indefinitely, without any time limit. Further, this Act was amended in 1967 to make the use of English, in addition to Hindi, compulsory in certain cases. 3. Regional languages. The Constitution does not specify the official language of different states. In this regard, it makes the following provisions. 1. The legislature of a state may adopt any one or more of the languages in use in the state or Hindi as the official language of that state. Until that is done, English is to continue as official language of that state. Under this provision, most of the states have adopted the major regional language as their official language. For example, Andhra Pradesh has adopted Telugu, Kerala, Malayalam, Assam, Assamese, West Bengal, Bengali, Odisha, Odia. The 9 northern states of Himachal Pradesh, Uttar Pradesh, Uttarakhand, Madhya Pradesh, Chhattisgarh, Bihar, Jharkhand, Haryana, and Rajasthan have adopted Hindi. Gujarat has adopted Hindi in addition to Gujarati. Similarly, Goa has adopted Marathi in addition to Konkani. Jammu and Kashmir has adopted Urdu, and not Kashmiri. On the other hand, certain northeastern states like Meghalaya, Arunachal Pradesh, and Nagaland have adopted English. Notably, the choice of the state is not limited to the languages enumerated in the 8th schedule of the Constitution. 2. For the time being, the official language of the Union, i.e., English, would remain the link language for communications between the Union and the states or between various states. But, 2 or more states are free to agree to use Hindi, instead of English, for communication between themselves. Rajasthan, Uttar Pradesh, Madhya Pradesh, and Bihar are some of the states that have entered into such agreements. The Official Languages Act, 1963, lays down that English should be used for purposes of communication between the Union and the non-Hindi states, that is, the states that have not adopted Hindi as their official language. Further, where Hindi is used for communication between a Hindi and a non-Hindi state, such communication in Hindi should be accompanied by an English translation. 3. When the President, on a demand being made, is satisfied that a substantial proportion of the population of a state desire the use of any language spoken by them to be recognized by that state, then he may direct that such language shall also be officially recognized in that state. This provision aims at protecting the linguistic interests of minorities in the states. Language of the judiciary and texts of laws. The constitutional provisions dealing with the language of the courts and legislation are as follows. 1. Until Parliament provides otherwise, the following are to be in the English language only. A. All proceedings in the Supreme Court and in every High Court. B. The authoritative texts of all bills, acts, ordinances, orders, rules, regulations, and bylaws at the central and state levels. 4. 2. However, the governor of a state, with the previous consent of the President, can authorize the use of Hindi or any other official language of the state, in the proceedings in the High Court of the state, but not with respect to the judgments, decrees and orders passed by it. In other words, the judgments, decrees and orders of the High Court must continue to be in English only, until Parliament otherwise provides. 3. Similarly, a state legislature can prescribe the use of any language, other than English, with respect to bills, acts, ordinances, orders, rules, regulations or bylaws, but a translation of the same in the English language is to be published. The Official Languages Act of 1963 lays down that Hindi translation of acts, ordinances, orders, regulations, and bylaws published under the authority of the President are deemed to be authoritative texts. Further, every bill introduced in the Parliament is to be accompanied by a Hindi translation. Similarly, there is to be a Hindi translation of state acts or ordinances in certain cases. The Act also enables the governor of a state, with the previous consent of the President, to authorize the use of Hindi or any other official language of the state for judgments, decrees and orders passed by the High Court of the state, but they should be accompanied by an English translation. For example, Hindi is used in Uttar Pradesh, Madhya Pradesh, Bihar, and Rajasthan for this purpose. However, the Parliament has not made any provision for the use of Hindi in the Supreme Court. Hence, the Supreme Court hears only those who petition or appeal in English. In 1971, a petitioner insisted on arguing in Hindi a habeas corpus petition in the Supreme Court. But, the court cancelled his petition on the ground that the language of the court was English and allowing Hindi would be unconstitutional. The Authorized Translations, Central Laws, Act of 1973 lays down that a translation in any regional language specified in the 8th Schedule to the Constitution, other than Hindi, of any central act, ordinance, order, rule, regulation, and bylaw published under the authority of the President in the Official Gazette is deemed to be the authoritative texts thereof in such language. Special Directives. The Constitution contains certain special directives to protect the interests of linguistic minorities and to promote the development of Hindi language. There are: protection of linguistic minorities. In this regard, the Constitution makes the following provisions. 1. Every aggrieved person has the right to submit a representation for the redress of any grievance to any officer or authority of the Union or a state in any of the languages used in the Union or in the state, as the case may be. This means that a representation cannot be rejected on the ground that it is not in the official language. 2. Every state and a local authority in the state should provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. The President can issue necessary directions for this purpose. 5. 3. The President should appoint a special officer for linguistic minorities to investigate all matters relating to the constitutional safeguards for linguistic minorities and to report to him. The President should place all such reports before the Parliament and send to the state government concerned. 6. Development of Hindi language. The Constitution imposes a duty upon the Centre to promote the spread and development of the Hindi language so that it may become the lingua franca of the composite culture of India. 7. Further, the Centre is directed to secure the enrichment of Hindi by assimilating the forms, style and expressions used in Hindustani and in other languages specified in the 8th Schedule and by drawing its vocabulary, primarily on Sanskrit and secondarily on other languages. At present, 2019, the 8th Schedule of the Constitution specifies 22 languages, originally 14 languages. These are Assamese, Bengali, Bodo, Dogri, Dongri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Mathili, Maithili, Malayalam, Manipuri, Marathi, Nepali, Adiya, Punjabi, Sanskrit, Santhali, Sindhi, Tamil, Telugu and Urdu. Sindhi was added by the 21st Amendment Act of 1967, Konkani, Manipuri and Nepali were added by the 71st Amendment Act of 1992, and Bodo, Dongri, Maithili and Santhali were added by the 92nd Amendment Act of 2003. In terms of the Constitution provisions, there are two objectives behind the specification of the above regional languages in the 8th Schedule. A. The members of these languages are to be given representation in the Official Language Commission, and b. The forms, style and expression of these languages are to be used for the enrichment of the Hindi language. Committee of Parliament on Official Language 9. The Official Languages Act, 1963, provided for the setting up of a Committee of Parliament on Official Language to review the progress made in the use of Hindi for the official purpose of the Union. Under the Act, this committee was to be constituted after 10 years of the promulgation of the Act, i.e., January 26, 1965. Accordingly, this committee was set up in 1976. This committee comprises of 30 members of Parliament, 20 from Lok Sabha and 10 from Rajya Sabha. The Act contains the following provisions relating to the composition and functions of the committee. 1. After the expiration of 10 years from the date on which the Act comes into force, there shall be constituted a Committee on Official Language, on a resolution to that effect being moved in either House of Parliament with the previous sanction of the President and passed by both Houses. 2. The committee shall consist of 30 members, of whom 20 shall be members of the House of the People and 10 shall be members of the Council of States to be elected respectively by the members of the House of the People and the members of the Council of States in accordance with the system of proportional representation by means of the single transferable vote. 3. It shall be the duty of the committee to review the progress made in the use of Hindi for the official purposes of the Union and submit a report to the President making recommendations thereon, and the President shall cause the report to be laid before each House of Parliament and sent it to all the state governments. 4. The President may, after consideration of the report, and the views, expressed by the state governments thereon, issue directions in accordance with the whole or any part of the report. The chairman of the committee is elected by the members of the committee. As a convention, the Union Home Minister has been elected as chairman of the committee from time to time. The committee is required to submit its report along with its recommendations to the President after reviewing the position regarding the use of Hindi in central government offices on the basis of its observations. Apart from adopting other methods for assessing the factual position, the committee decided to inspect certain central government offices representing various fields of activities to motivate the central government offices to adopt maximum usage of Hindi so that the objectives of the Constitution and Official Languages Act provisions could be achieved. With this end in view, the committee set up 3 subcommittees, and for the purpose of inspection by the 3 subcommittees, the various ministries/departments etc. were divided into 3 different groups. Further, in order to assess the use of official language for various purposes and other matters connected therewith, it was also decided to invite eminent persons from various fields such as from education, judiciary, voluntary organizations, and the secretaries of the ministries/departments etc., for oral evidence. The progressive use of Hindi in the central government offices is being reviewed by the committee in the background of the provisions relating to official language as provided by the Constitution, the Official Languages Act, 1963 and the rules framed thereunder. The committee also takes note of the circulars/instructions etc. issued by the government in this regard from time to time. The terms of reference of the committee being comprehensive, it has also been examining other relevant aspects like the medium of instructions in schools, colleges, and the universities, mode of recruitment to central government services and medium of departmental examination etc. Taking into consideration the magnitude of various aspects of the official language policy and keeping in view the present circumstances, the committee in its meeting held in June, 1985 and August, 1986 decided to present its report to the President in parts, each part relating to a particular aspect of the official language policy. The Secretariat of the Committee is headed by the Secretary of the Committee. The Secretary is assisted by the officers of the level of Under-Secretary and other officials. They extend all required assistance in performing the various activities of the Committee. For administrative purposes, this office is subordinate office of Department of Official Language, Ministry of Home Affairs. Classical language status. In 2004, the Government of India decided to create new category of languages called as classical languages. In 2006, it laid down the criteria for conferring the classical language status. So far, 2019, the 6 languages are granted the classical language status. This is shown below in Table 65.1. Benefits. Once a language is declared classical, it gets financial assistance for setting up a center of excellence for the study of that language and also opens up an avenue for 2 major awards for scholars of eminence. Besides, the University Grants Commission can be requested to create, to begin with at least in central universities, a certain number of professional chairs for classical languages for scholars of eminence in the language. 10. Table 65.1 Languages conferred with classical language status. SL No. Languages. Year of declaration. 1. Tamil. 2004. 2. Sanskrit. 2005. 3. Telugu. 2008. 4. Kannada. 2008. 5. Malayalam. 2013. 6. Adia. 2014. Table 65.2 Articles related to official language at a glance. Article No. Subject matter. Language of the Union. 343. Official language of the Union. 344. Commission and Committee of Parliament on Official Language. Regional languages. 345. Official language or languages of a state. 346. Official language for communication between one state and another or between a state and the Union. 347. Special provision relating to language spoken by a section of the population of a state. Language of the Supreme Court, High Courts, etc. 348. Language to be used in the Supreme Court and in the High Courts and for acts, bills, etc. 349. Special procedure for enactment of certain laws relating to language. Special directives. 350. Language to be used in representation for redress of grievances. 350A. Facilities for instruction in mother tongue at primary stage. 350B. Special Officer for Linguistic Minorities. 351. Directive for Development of the Hindi Language. Criteria. The criteria for declaring a language as classical mandates high antiquity of its early texts/recorded history over a period of 1,500 to 2,000 years, a body of ancient literature/texts which is considered a valuable heritage by generations of speakers and a literary tradition that is original and not borrowed from another speech community. Also, since the classical language and literature is distinct from the modern, there can also be a discontinuity between the classical language and its later forms or its offshoots. 11. Notes and references. 1. The commission was to consist of a chairman and other members representing the different languages specified in the 8th schedule of the Constitution. 2. The committee was to consist of 30 members, 20 from Lok Sabha and 10 from Rajya Sabha, to be elected in accordance with the system of proportional representation by means of the single transferable vote. 3. These include, a. Resolutions, general orders, rules, notifications, administrative or other reports or press communications issued by the central government, b. Administrative and other reports and official papers laid before Parliament, and c. Contracts and agreements executed, licenses, permits, notices, etc., issued by the central government or by a corporation or a company owned by the central government. 4. For language in Parliament and a state legislature, see the respective chapters, i.e., 22 and 33. 5. This provision was added by the 7th Amendment Act of 1956 on the recommendation of the States Reorganization Commission. 6. Ibid. 7. In 1976, the Supreme Court declared Tamil Nadu's pension scheme to anti-Hindi agitators as unconstitutional. 8. The 96th Amendment Act of 2011 substituted Adiya for Oriya. 9. This information is downloaded from the website of the Committee of Parliament on Official Language, Ministry of Home Affairs, Government of India. 10. The Hindu, Adiya gets classical language status, February 20, 2014. 11. Ibid. 66. Public services. Classification of services. The public services, civil services or government services, in India are classified into 3 categories: All India services, central services, and state services. Their meaning and composition are explained below. All India services. All India services are those services which are common to both central and state governments. The members of these services occupy top positions, or key posts, under both the center and the states and serve them by turns. At present, there are 3 All India services. They are: 1. Indian Administrative Service, IAS. 2. Indian Police Service, IPS. 3. Indian Forest Service, IFS. In 1947, the Indian Civil Service, ICS, was replaced by IAS, and the Indian Police, IP, was replaced by IPS and were recognized by the Constitution as All India Services. In 1966, the Indian Forest Service was established as the 3rd All India Service 1. The All India Services Act of 1951 authorized the central government to make rules in consultation with the state governments for the regulation of recruitment and service conditions of the members of All India Services. The members of these services are recruited and trained by the central government but are assigned to different states for work. They belong to different state cadres, the center having no cadre of its own in this regard. They serve the central government on deputation and after completing their fixed tenure they go back to their respective states. The central government obtains the services of these officers on deputation under the well-known tenure system. It must be noted here that irrespective of their division among different states, each of these All India services form a single service with common rights and status and uniform scales of pay throughout the country. Their salaries and pensions are met by the states. The All India services are controlled jointly by the central and state governments. The ultimate control lies with the central government while the immediate control is vested in the state governments. Any disciplinary action, imposition of penalties, against these officers can only be taken by the central government. Sardar Vallabhbhai Patel was the chief protagonist of All India services in the Constituent Assembly. Hence, he came to be regarded as the father of All India services. Central services. The personnel of central services work under the exclusive jurisdiction of the central government. They hold specialized, functional and technical, positions in various departments of the central government. Before independence, the central services were classified into Class I, Class II, subordinate, and inferior services. After independence, the nomenclature of subordinate and inferior services was replaced by Class III and Class IV services. Again in 1974, the classification of central services into Class I, Class II, Class III, and Class IV was changed to Group A, Group B, Group C and Group D, respectively too. At present, there are 62 Group A central services. Some of them are: 1. Central Engineering Service. 2. Central Health Service. 3. Central Information Service. 4. Central Legal Service. 5. Central Secretariat Service. 6. Indian Audit and Accounts Service. 7. Indian Defence Accounts Service. 8. Indian Economic Service. 9 Indian Foreign Service, 10 Indian Meteorological Service, 11 Indian Postal Service, 12 Indian Revenue Service, Customs, Excise, and Income Tax, 13 Indian Statistical Service, 14 Overseas Communication Service, 15 Railway Personnel Service. Most of the above cadres of Group A Central Services have also corresponding Group B services. The Group C Central Services consists of clerical personnel while Group D consists of manual personnel. Thus Group A and Group B comprises of gazetted officers while Group C and Group D are non-gazetted. Among all, the Indian Foreign Service, IFS, is the highest central service in terms of prestige, status, pay and emoluments. In fact, it, though a central service, competes with the All India services in position, status, and pay scales. It comes next to the IAS in ranking and its pay scale is higher than the IPS. State Services. The personnel of state services work under the exclusive jurisdiction of the state government. They hold different positions, general, functional, and technical, in the departments of the state government. However, they occupy lower positions, in the administrative hierarchy of the state, than those held by the members of the All India Services, IAS, IPS, and IPS. The number of services in a state differ from state to state. The services that are common to all the states are 1. Civil Service, 2. Police Service, 3. Forest Service, 4. Agricultural Service, 5. Medical Service, 6. Veterinary Service, 7. Fisheries Service, 8. Judicial Service, 9. Public Health Service, 10. Educational Service, 11. Cooperative Service, 12. Registration Service, 13. Sales Tax Service, 14. Jail Service, 15. Service of Engineers. Each of these services is named after the state, that is, name of the state is added as a prefix. For example, in Andhra Pradesh, AP, they are known as AP Civil Service, AP Police Service, AP Forest Service, AP Agricultural Service, AP Medical Service, AP Veterinary Service, AP Fisheries Service, AP Judicial Service, and so on. Among all the state services, the Civil Service, also known as the Administrative Service, is the most prestigious. Like the central services, the state services are also classified into 4 categories: Class I, Group I or Group A, Class 2, Group 2 or Group B, Class 3, Group 3 or Group C, and Class 4, Group 4 or Group D. Further, the state services are also classified into gazetted class and non-gazetted class. Usually, Class I, Group A, and Class 2, Group B, services are gazetted classes while Class 3, Group C, and Class 4, Group D, services are non-gazetted classes. The names of the members of gazetted class are published in the Government Gazette for appointment, transfer, promotion and retirement, while those of the non-gazetted are not published. Further, the members of the gazetted class enjoy some privileges which are denied to the members of non-gazetted class. Also, the members of the gazetted class are called officers while those of non-gazetted are called employees. The All India Services Act of 1951 specifies that senior posts not exceeding 33 1/3% in the Indian Administrative Service, IAS, Indian Police Service, IPS, and Indian Forest Service, IFS, are required to be filled in by promotion of officers employed in the state services. Such promotions are made on the recommendation of selection committee constituted for this purpose in each state. Such a committee is presided over by the chairman or a member of UPSC. Constitutional Provisions. Articles 308 to 314 in Part 14 of the Constitution contain provisions with regard to all India services, central services, and state services. 1. Recruitment and service conditions. Article 309 empowers the Parliament and the state legislatures to regulate the recruitment and the conditions of service of the persons appointed to public services and posts under the centre and the states, respectively. Until such laws are made, the President or the Governor can make rules to regulate these matters. Recruitment includes any method provided for inducting a person in public service like appointment, selection, deputation, promotion, and appointment by transfer. The conditions of service of a public servant includes pay, allowances, periodical increments, leave, promotion, tenure or term.